Yes.
Yes.
First, it's a suit of partition.
Please, my lords.
It's not a suit of declaration of ownership.
Yes, yes.
So, to grant a blanket injunction
Yes.
was absolutely wrong.
But it
You
is,
can, in a partition suit, say don't change nature and character.
That's all,
But you
my
can't
lords.
stop a co-owner or a co-sharer or a co-parsoner
Yes.
from transferring his or her share.
yes.
Mutually convenient and consensual arrangement pending disposal of the partition suit. You have one. We are just saying come up with a mutually
Well-
convenient and acceptable arrangement pending disposal of the suit. We adjourn by 2 weeks.
Very well.
Milords, I am for the response number 7. Milords, in fact, there are.
To arrive at a consensus,
Milords,
vis-a-vis an interim arrangement to be made
On the monetary aspect, my lords.
pending disposal of the suit. Yes.
Milords, I am also one of the Milords, the branches, Milords, where in fact there was a partition in 2003. Please, Milords.
Discuss.
Yes, Milords, we will also be part of the Milords discussion
Number
because
8 may be given.
No, no,
Because
your lordship
this
has
is
not
not the
issued notice,
serious
your
We
matter.
have not issued notice.
What is the query? The
No,
question.
my lords, my lords are keeping out on some particular day.
When do you want it? How much time?
1 week. 1 week.
List next week.
Milords, Lordship may consider
When do you
mediation,
want it?
Milords.
Can be it
Today
Monday,
is
Monday
23rd.
or 2nd, my lords, the 2nd.
List on
Or maybe 29th, my lords.
29th, I have a difficulty.
2/7. List on 2/7.
2/7, my lords.
May your Lordship consider mediation, Milords, because there are family disputes.
No. The suit is pending. No mediation.
As your Lordship.
After some time,
Can
we
it
may
be on,
have.
my lords, my briefing, can it be 4th or 5th, my lords? Third or fourth.
Want it?
Third or fourth, my lords. Instead of 2nd, can be
Let
third, my
it,
lords.
let it
List
not
on
come
3/7.
before the
Grateful.
discussion.
3/7.
Grateful, my lords.
3/7.
Well, instead of that, will not let it be on 6th. 6th.
Want it on 6th.
I also have noticed.
6/7.
6th.
Grateful.
I am so glad.
Yes.
Right. Milords, any steps taken by the Milords,
Nothing. We are not saying anything.
Milords, court receiver would be subject to Milords, the SLP.
We are not saying anything. Come up
As a
with
lordship.
A suit for partition filed by a special child through mother. Trial court restrained saying don't sell the properties. That is all. In the division,
all co-parsoners is 1/5 shareholder. Mr. Chaudhary,
No,
if there's an injunction, can't be beyond your share.
1/5 share.
He is claiming that.
is the
Not
the
me.
trial court
He
has
is claiming.
Receiver has been appointed.
the only
He did not
issue
have
is so far as whatever that share is, that is to be determined. It's a
Why
undivided
are you aggrieved by the appointment of the
of receiver. That's all, Malazdi. How
Why are
can
you aggrieved?
yes, I'm agreed, Malazdi.
Why?
But the position is that the whatever these properties are, whatever the rent is coming, the special child need are being taken care through that only because he
No,
has
that's
got
all right. What is your share?
1/5.
Now you appropriated the entire.
No, that
property
question.
when they were in
But that is
judicial custody.
Court has said, court told me, please file your records that whatever the revenue coming
there
to
is
you out of this,
matrimonial
they can determine the.
Two very important things which
Yes.
are the trial court missed.
Yes,
First, it's a suit of partition.
please,
It's
Malaz.
not a suit of declaration of ownership.
Yes, yes.
So, to grant a blanket injunction
Yes.
was absolutely wrong.
But it
You
is,
can, in a partition suit, say don't change nature and character.
That's all,
But you
Malaz.
can't stop a co-owner or a co-sharer or a co-parsoner
Yes.
from transferring his or her share.
Malaz, to that extent, I have no
To that
difficulty.
extent, it's
That-
absolutely
all I'm saying-
permissible under the
No,
act.
I'm,
Therefore, they went in appeal. Now the
that
High
extent
Court
is
says,
really
High Court has said,
Rightly
let
believed.
there be a
yeah, no
Receiver
difficulty. Just to solve to this problem, Malaz. They made a statement they do not wish to alienate the property. There's a statement given by their lawyer during the arguments. I have no difficulty, and I have no difficulty. Whatever their share is, they can do whatever they wish to do it. I have no problem on that part. So far as the other any aspect related to the property is concerned, what is the need of the receiver to be appointed in those cases? That can't be determined.
See,
They
that's
can't be
not-
determined. All of them.
commercial property, etc.
No, there's a multiple types of the properties. I'm not saying there's a multiple types of properties.
Go and ask.
And no one asked for
Modification.
No one has asked for the one is there is
Go
no
and ask
prayer.
for
Yes,
modification.
both of us will go and.
There is no prayer by either side. Today order 40 can't be
What
invoked.
should be the interim arrangement?
Yes.
What should be the interim arrangement?
Interim arrangement, Mullah, is that so far as they made their statement, they don't want to wish to deal with the properties.
That's
Time
all
being
right.
because that's
With
fine.
regard to the other monetary aspect.
Other monetary, yes, I make myself clear. in the para other than the one where receiver has been appointed in the order, I'll file my all record before the trial court. Trial court determined that how it is to be disbursed. I have no difficulty. And I filed an affidavit before the court. I said I'll place everything before the trial court. Let the trial court decide on that part. But where they need a receiver today,
Now what happens?
and there's
is
no
because-
prayer of the receiver. And
See,
they made
now
this-
the properties are, you see, the arrangements are under your control.
What has happened
can't
is
happen.
all the defendants,
Arrested.
all the
No,
defendants
no.
are under Makuka. They have been arrested. All of them
Very
they've been
unfair.
arrested behind bars.
That's all right. That time you took control.
No, today well, somebody because these properties are today
You can't-
rented, leased. Somebody
Arrive,
need to deal with it.
arrive, if you don't want the receiver,
Yes.
mutually convenient and consensual arrangement pending disposal of the partition suit, you have one.
May I request for this?
Receiver is already appointed now.
This aspect, my lords, can direct the trial court to determine. I have no difficulty. Please remove the receiver. Let the trial court determine. I'll make submission. I'll file everything. Let the trial court take a view. Where is the question of receiver being appointed?
So
Receiver is
what-
very,
Milord,
very
what
serious
happens-
step. Receiver is a very, very serious step. It
Yes,
prejudices
now-
everything.
Why
I'll
you
tell
want
you,
to
Lordship, I'll
hand
suggest
over
something.
for-
Why we are not interested in modifying the injunction, you see in paragraph 28, the judge unilaterally
Unilaterally
receiver on
No,
a-
I agree, Milord. Therefore, I have a suggestion to make.
So
I
if
have a
you
suggestion.
can have a suggestion
You
of.
make-
I have a suggestion to
Ask
you.
for modification of this order.
We both of us will go.
Arrange-
Only one thing, Your Lordship may please
Arrange-
consider.
Let-
But one factor Your Lordship may also consider. What happens is this.
Yes. I'm very fair. It's very fair. My lords, may I suggest how to possibly formulate a outcome of this? I will, please remove the receiver. Within 2 weeks, I'll file the accounts before the trial court. Let the trial court determine whatever the way it is to be appropriated by the party. That
I
also
will,
can be done.
may I suggest one thing? Milord?
No, go for
I have
modification.
another
Go to
suggestion.
High Court itself.
I have another suggestion to make.
Trial court would be better in my respect.
I have
no
another,
difficulty. I can
I have
go to High Court
another
also.
suggestion to make, Milord. Now, what happens is, in terms of this injunction, Milord, I was only restrained from creating third-party interest. Now, I challenge it before the High Court. During the meantime, Milord, the prayer in the suit by them is for possession also. So, possession was not admittedly with them. Possession was with us. Milord, taking benefit of this, Milord, injunction, and then we were arrested at her instance. Milord, she takes the possession of the property and starts getting. Just one second.
It's factually
Just,
not
just
right.
one second. Just
I
one
can-
second. Just one second.
Control.
But
Just
that's
she
right.
took-
Today
she
it's only
takes
the-
control. And that's
These
the
properties
reason.
are the
Just one
possession of the
second.
tenants.
Just one second. Now that is the reason why, Milord, the High Court says you could not have taken possession when the prayer were for possession. You could have at the most got 1/15th of share, right? That's the only prayer which she had. Now, therefore, the High Court says that let the receiver be appointed and you may make an application to the trial court for becoming agent of receiver. So she is
No,
also
why
given
not?
liberty.
Why receiver?
Even I also agree, Milord. Now, therefore, what best can be done? I have an alternative suggestion. Now, Milord, so far as 15% is concerned, that's what the child is entitled to. We will keep it in the escrow account.
Today,
So,
that can,
just one
No,
second.
they also require.
this can't be.
Therefore, Milord, both the
in
courts
my
have-
suit,
just
fellas,
one
how can they claim
Now,
the receipt?
no, but then you can't take possession of the property.
That is
Therefore-
not-
We are not
therefore-
of possession
My lords are
now.
therefore that.
Therefore, Milord, what I am suggesting,
Monetary arrangement.
Partition
right?
suit,
So
there is-
15%,
Everyone is a co-plaintiff.
Yes.
right?
That's what I'm saying.
And therefore, injunction against the Milord co-owner could not have been granted by the
Yes.
trial court, even
Also
though
to be
I.
taken into consideration. He's a co-sharer.
He can-
Your portion, according to your claim,
Yes.
is 1/15 plus
1/5 of
1/5.
certain properties, yes.
That 1/5 she can't claim because the husband is alive.
Ah, yes.
You can't claim, the wife can't claim.
Under the
She can
Bombay
only be
suit,
entitled for maintenance, if
The
at all.
son gets a share, she will get a share.
That's
Therefore,
what on that
she can't
is-
even claim him.
Well, the-
share.
all I- So, but all
So
I'm
at
saying,
best,
all I'm
Milord,
saying
let
is,
them go to the
We
High
can-
Court
we
and
can-
move an
We
application.
cannot.
receiver has to go, Malats. Receiver has to
But
go.
possession she can't retain.
Matter,
Yeah.
both parties come up with a joint memo as to how this matter has to be, the arrangement has to be made pending the disposal of the suit. In terms of that, we will dispose
But-
of the SLP.
Milord, property cannot be
Come up-
retained by her.
Come up with a joint memo.
We will do that, Milord. We'll do that. But then,
May-
Milord, what I'm saying is, Lord, since he has taken over the property illegal, Lord, that's what the High Court has said. You can't take it up. You could not have taken it up.
Well,
by
that's
taking
not
it-
the question
That's
today.
the question.
If it is
That's the question.
Only
You
the
remove that
monetary
through law.
aspect of it,
Sorry.
monetary aspect.
That's all.
That's
Today,
what, Lord. So far as
Both of
15
you come up with a joint memo.
We will do
Milords,
that.
I am for one of the caveats, Milords.
the
Lordship, permit me.
the issue is that and I'm saying that I'll file.
Have a consensus, at least as to how pending disposal of the
We'll
suit.
have to take instructions of.
Oh, yes, we
Milords.
will adjourn it.
Milords, I am for the response number 7, Milords.
Receiver is already
in the
appointed.
meantime,
No, he's already appointed.
That's what I'm saying. The
He's already
yesterday it has been
appointed.
done. The receiver should not proceed further.
No,
in
he's
the
already
meantime.
appointed.
Kindly keep it next week, and I'll do that, Malas.
Yes,
And let him take instructions on that.
when will you come up with a joint memo?
Malas, we can.
File a joint memo.
I have no instruction as of
All
now,
right.
Lord, my class.
Let's
not
keep it
issue
next week.
notice.
Whatever the outcome is, we'll place
All
it.
right, find out.
Milords, I am for response number 7, Milords. In fact, I
Receiver
am.
should not proceed based on this order, Malas.
That
We
can't
are
I'm
not-
taking.
we are not saying it, we are not issuing notice. We are
See-
just saying come up with a mutually
Very-
convenient and acceptable arrangement pending disposal of the suit.
Malas, the-
So that both of you are having control over the property.
Very well.
not the-
Milords, I am. Milords,
In the
Milords.
meantime,
In the
receiver
meantime,
should not move further on this. Malas. What is the point?
No,
Today they
if you come up with this, we'll set aside that order.
All I'm
We are
saying
not
is,
saying
please,
anything.
at least the status quo as on
No,
today.
it
Malas.
can't be
It's
that.
not going to help anyone. It's today nobody is disputing.
Nothing, we adjourn by 2 weeks.
Very well.
Milords, I am for the response number 7, Milords. In fact, there are. in-
To arrive at a consensus,
Milords,
vis-à-vis an interim arrangement to be made
On the monetary aspect, Malas.
pending disposal of the suit. Yes.
Milords, I am also one of the Milords, branches, Milords, where in fact there was a partition in 2003. Please, Milords.
Discuss.
Yes, Milords, we'll also be part of the Milords discussion
Honorable
because
date may be given.
No,
in
no,
this
your
because this
lordship
is
has not
not the
issued notice,
serious
your
We
one.
have not issued notice.
What is the query? The
No,
question.
Malas, the Malas are keeping out on some particular day.
When do you want it? How much time?
1 week. 1 week.
List next week.
Milords, Lordship may consider
When do you
mediation,
want it?
Milords.
Can be it
Today
Monday,
is
What is the date?
23rd.
or second, Malas, the second.
List on
Or maybe 29th, Malas.
29th, I have a difficult.
2/7. List on 2/7.
2/7. Malas.
May your Lordship consider mediation, Milords, because there are family disputes.
No, the suit is pending, no mediation.
As a Lordship.
After some time,
Can
you
it be
may
on,
have.
Malas, my briefing, can it be 4th or 5th, Malas? Third or fourth.
Want it?
Third or fourth, Malas. Instead of second, can be
Let
third.
it,
Malas.
let it
List
not
on 3/7.
before the
Grateful.
vacation.
3/7.
Grateful, Malas.
3/7.
Well, instead of that, will not let it be on 6th. Will not. 6th.
Want it on 6th.
I also have noticed.
6/7.
6th.
Grateful.
I'm so glad.
Yes.
Right. Was any steps taken by the Milords,
Nothing, we are not saying anything.
Milords court receiver would be subject to Milords, the SLP?
We are not saying anything. Come up
As a
with
lordship.
an arrangement.
Yes, Milords, obliged.
Are you just challenging the